The hidden strategy in DMV refusal cases. Most people think refusing a DUI chemical test means you automatically lose your license for a year. But what if I told you there's a hidden DMV strategy that can buy you more driving time and even improve your chances of keeping your license? Let's break it down. Hi, I'm Hieu Vu, a California criminal defense attorney, and on this channel, we break down real-world DUI defense strategies that most people don't hear anywhere else, especially the stuff these won't tell you. If you or someone you care about are facing a DUI refusal, this video matters. Stick with me because I'm going to show you how strategic delays and the right steps at your DMV hearing can literally keep you driving longer while your case is pending. Before we jump in, save this video so you can reference it later, and drop a comment if you want me to walk through sample DMV hearing mistakes you must avoid. What is a DMV refusal hearing and why it matters? When you refuse a breath or blood test after a DUI stop in California, you face a DMV refusal hearing where the Department of Motor Vehicles decides whether to suspend your license for 1 year. If you lose that hearing, your license is suspended with no restricted license available for a full year. But here's a key detail. Once you request your DMV hearing on time, your license suspension is paused. This is called a stay on the suspension. That means as long as your hearing is pending, you can legally keep driving beyond the initial 30 days after your arrest. Some clients have kept their driving privileges for months by strategically handling the hearing schedule. Why most people lose these hearings. Even though delays help, most people still lose their DMV refusal hearings. Why? The biggest reason is the refusal itself. Video and audio often shows the officer clearly advise the driver of the consequences, and that can be nearly impossible to overcome without technical defenses. The biggest mistakes people make. Here are the common pitfalls that do many DMV refusal cases. Not requiring critical evidence. Most people fail to subpoena body camera, dash camera, or station video. Without it, it's just your word versus the officer's. Failing to ask for the stay on suspension. That's not automatic in every case. You have to specifically request it when you set your hearing, or your license will be suspended after 30 days. The best and worst case scenarios. Your best chance of winning a DMV refusal case is if the officer did not advise you of refusal consequences, or there's inconsistencies in the paperwork or audio video evidence. Your worst case scenario is when everything is clear, consistent, and properly advised. Then the DMV almost always upholds the suspension. Now, here's the part most people don't expect, how an attorney can actually influence the timeline and outcome. So let's recap. Refusing a DMV chemical test triggers a DMV refusal hearing where your license can be suspended for 1 year. A strategic delay can cause that suspension and buy you valuable driving time. The two biggest mistakes people make are not requesting the right evidence and not asking for a stay on the suspension. And the best outcomes often hinge less on the refusal itself and more on procedural details and evidence challenges. If you think your refusal hearing is lost before it even starts, consider this. Sometimes the lack of video evidence works in your favor. Without body cam or dash cam, the DMV has to prove you were properly advised, and uncertainty in an advisement can be enough to win or set the refusal aside. If this video helped you understand a strategy most people never hear about, save it and share it with someone facing a DUI refusal. If you're dealing with the DMV refusal hearing right now, or just got that pink temporary license, call the law office of Hieu Vu for a consultation. We can help you buy more time and fight your driving privileges. Contact info is in the description.